This is case 2018-0468, Appeal of Northern Pass Transmission, LLC et al.
Before we begin, just for scheduling purposes, you should know that we will hear the argument for the appellant, and then we will take a brief recess, and then we will hear the arguments from the appellees. All right, Mr. Glan?
Good morning, and may it please the Court. Bill Glan and McLean Middleton for Northern Pass Transmission and Eversource. The Northern Pass Transmission Project would deliver more than 1,000 megawatts of clean, renewable energy to New Hampshire and New England from Canadian hydropower sources and provide millions of dollars of benefits to the state. RSA 162 required that the subcommittee consider and weigh all of the significant benefits and impacts of this project. It failed to do so. Instead, it truncated its deliberations and rested its decision for the first time in the history of the SEC on alleged failure of an applicant to meet their burden of proof. In doing so, they made three errors. First, the subcommittee failed to follow its own statute and rules by failing to consider all evidence in the record, failing to consider mitigation measures, and failing to consider and weigh all of those benefits and impacts.
From where does the obligation to consider mitigation measures arise?
It arises, Your Honor, from the simple fact that mitigation is an essential element of the burden of proof in these administrative proceedings. Every project that has ever been approved by the SEC includes mitigation measures. The Antrim Wind case that you decided last year is a great example. Without mitigation, that project could not have been built.
Right.
The second error that they made was that, contrary to their own rules, they applied the wrong burden of proof. And in measuring that burden of proof, they applied ad hoc standards developed solely for this proceeding. In short, to the extent that any applicant could know where the goalposts were in a case like this, they moved them.
Mr. Glan, I guess the thing that I'm not clear of, to sort of follow up on Justice Hick's question, is it seems to me that this case is significantly different from, for example, the case that comes to mind, and I know that Justice Hicks and I had a disagreement on that case also, but the gas transmission case, the gas pipeline, in that statute, the statute said, consider all of these factors. It didn't say, in order to grant this approval, you have to find A, B, C, and D. It said, consider all these factors, and the majority in that case said, well, you can't truncate that and just consider some factors. You have to consider everything. But the statutory scheme here seems to be very similar, for example, to what a local land use board would do in considering an application, let's say, for a variance. That in order to grant the variance, you have to find A, B, C, D, and E. And it frequently happens that a zoning board will say, well, we don't have to consider B, C, D, and E because the applicant didn't meet the burden on A. Isn't that really what this statutory scheme says? You can't, in order to grant approval, the site committee has to find that A, B, C, and D, or E, whatever it is, all of them are met. And they say, we don't have to go any further because A isn't met.
So, yes, Your Honor, the statute does not require necessarily that you consider every one of those factors, but it gets to my third error. And that third error is, where this subcommittee made a fatal error was that they incorporated elements from another one of those statutory factors into their decision improperly. And they decided this case in large part based on aesthetics of the line, including rural character and scenic beauty as set forth by various municipalities.
Where is it precluded that can be considered, or why can't it be considered in regard to the economic issues and all on that first?
It can, Your Honor, but if you are going to consider it, you need to consider it under the rules that this subcommittee has adopted. In other words, first of all, the legislature did not place aesthetics in subpart B of Section 16. They put it in Section C. There's no indication that the legislature or the SEC ever intended aesthetics to be addressed as a separate consideration.
But if aesthetics have an impact on tourism or on the economy.
Absolutely. And here's the problem. There is a very specific way to deal with aesthetics within the statute. Visual impact assessments. There were two visual impact assessments in this case. The applicant's 650 scenic resources considered in that visual impact analysis. For the CFP, 7,000. So when you're considering aesthetics, there's a very prescriptive and detailed way that you are supposed to consider it. And this subcommittee imported aesthetics into this, not necessarily improperly if you do the right analysis. But if you don't do the right analysis, you're just making a decision on aesthetics on purely subjective grounds. To a certain degree, aesthetics is always going to be somewhat subjective. But there is a very specific way under the visual impact analysis in the Site 301.14 rule as to how you are supposed to do that. So what they did was to say, we are going to make a decision based on aesthetics, but we are never going to look at the aesthetics evidence in this case. That alone is a sufficient basis to reverse this decision.
So because of the overlap between the various categories, the proper procedure would have been for the committee to step through all four analyses before then incorporating conclusions in other arenas into this particular conclusion.
Exactly, and that's exactly what the subcommittee did in the SRP proceeding, where we provided the additional authority on that. In other words,
But evidence isn't siloed. I mean,
I'm sorry?
evidence can be used for various factors.
yeah, but I'm sorry, I didn't entirely hear your question.
I mean, evidence doesn't come in with a particular tag on it, and it only can be used in a silo. This is a gestalt. All the information is before the committee for any purpose.
Of course not, but if you are going to include aesthetic, let me say it a different way. The municipal views section of this order primarily focuses on two issues: scenic resources and rural character. The SEC rules have a proxy for how you determine impact on rural character and scenic beauty. And it's in Site 102.45, which is the rule that defines what a scenic resource is. Scenic resources under their rule includes anything the city or the municipality designates as scenic, conservation lands, lakes, rivers, streams, parks, tourist destinations, recreational trails, historic sites, town and village centers. So if you want to know what the impact on them is, you need to do the analysis of scenic resources that's covered by the SEC rule.
Wouldn't a view suffice, and wasn't there a view taken in this case?
There were views, Your Honor, and nowhere in this record is there any factual statement by this subcommittee that based on that view, we make a determination that, nor would that be appropriate without the visual impact assessment. But remember one other thing about this. 162 HC 16C describes aesthetics as an unreasonable adverse impact standard. So you can't just say, well, we're considering aesthetics and we think it affects rural character. If it's going to affect aesthetics, the subcommittee has to ultimately make a determination under the proper rule, which is 301.14 and the visual impact assessment, of whether in fact that visual impact arises to an unreasonable adverse impact. So part of their problem here was they had all this evidence that they could have considered on visual impacts. They never did so. And the end result of that is this.
Well, can I just ask you, though, Mr. Gahn, when you say they never did so, what you're really saying is that they never wrote down in their order, we did so. But don't we have a general policy that, you know, when the question is sufficiency of the evidence, we sort of assume that they made the findings that would support their decision if the record would support that conclusion. So if they didn't, the fact that, you know, they didn't write down they didn't put in writing the specific analysis that you say, that doesn't mean that they didn't do it, does it?
Well, Your Honor, I would beg to disagree with you on that, because in this case, we know they didn't do it. We know for two reasons. One is they halted their deliberations before they got to that factor at all. They said at the end of their deliberations on orderly development, we're going to take a straw vote. Nothing's been decided yet. We're going to go on and consider the other things. And then after a lunch break, they came back and said, we're going to stop now. They never deliberated on that issue at all, and they certainly never considered the visual impact statements in their deliberations. And the second reason we know it is because there are no findings of fact on it at all. There's no findings of fact that these aesthetic effects would have an unreasonable adverse effect.
So far, we've skirted around the orderly development issue. Why wasn't the burden of proof satisfied, and why wasn't the burden of production satisfied on that issue?
On the aesthetic issue?
Orderly development.
Oh, okay. Well, the subcommittee's decision on that was, first of all, they applied the wrong burden of proof. On both land use and property values, what they said was the applicant did not meet its burden in demonstrating that the project's impact on property values or land use would not unduly interfere with the orderly development of the region. That's not the standard. We are required in our application to set forth an estimate of what the effects of the project will be on those areas. Ultimately, our burden of proof is only to put forth sufficient facts for them to be able to make ultimately the orderly development of the region decision. And you don't have to take our word for that, because the NGOs in their brief specifically say the applicants did not have to prove the project's impact on each 301.9 factor, that would fall below the level of undue interference. So what the committee was required to do was to take the evidence of those estimates that they had in the record, weigh them all as part of the, as you know, there are 3 elements of orderly development of the region: land use, the economy, and employment. Within employment, within the economy, there are 6 separate subparts. So what they were required to do is take those 6 subparts, determine what the estimates were, weigh them all together, consider them with land use and employment, and ultimately make the determination of whether the project unduly interfered. They didn't do that. And the other point, Justice Hicks, is that there was plenty of evidence in the record put forward by counsel for the public as to what the estimate of effects in any one of these areas would be. They never considered that. In their order, they spent most of their time criticizing our experts, as though there were no cross-examination in this case at all. But because they didn't criticize the evidence that was put forward by the counsel for the public's experts, they at least should have considered it. And in this case, there's even a better reason why it should have been considered, and that's because counsel for the public has a different role in this case from simply a litigant. Counsel for the public is appointed by the Attorney General to represent the public interest in these cases. And here's what the counsel for the public said when they sought to become a party in this case: that they had to apply for approval for us to pay for their experts. And they said they would provide an unbiased, independent, and thorough analysis of the project's benefits, an objective and reliable understanding of those benefits. They charged Eversource, or Northern Pass, $2.1 million for those experts. Their opinions clearly set forth an estimate of what the benefits and detriments or impacts of this project would be. The subcommittee simply said, well, if we don't like the reliability of your experts, we don't have to look at that at all. In a quasi-judicial proceeding like this, our position is that where the SEC has an independent ability to investigate, conduct studies, etc., and the CFP has a similar duty or ability, that ignoring that evidence of what the impacts were, was simply arbitrary and
So,
unreasonable.
Mr. Glahn, say we agree with you. What do you want us to do? You've said you want us to vacate and basically go back and tell them to do their jobs and spend a little bit more time on it. Do you want to reopen the record? What do we do about the fact that the committee now has different members than it had at the time? There are a lot of practical issues here.
Well, with respect, Your Honor, that is a situation that often occurs in this state. In other words, cases are appealed to this court from administrative agencies. The court vacates the decision. It goes back to the administrative agency, and the administrative agency may not have the same members. We're not asking you to reopen the record in the SEC. If Northern Pass and Eversource decided that they wanted to change the scope of the project, that would be different. But simply because there are new members, this decision where the subcommittee decided this primarily, almost exclusively on a matter of law, was that these expert witnesses either were not reliable or the other evidence was. And what I'd say let me finish my answer to your question and then I'll make the other point, which is new members of the SEC or subcommittee could clearly read the transcripts of the hearing in this case and make the same kinds of decisions.
Do they get to go on a view?
Pardon?
Do they get to go on a view?
I don't know the answer to that question, Your Honor, but they could. to follow up on one point. Having put forth the evidence from the CFP's experts, from KRA primarily, the subcommittee never says in this order, well, we credit this testimony over the other. What they say is, all of this testimony is unreliable. Therefore, we don't have to address this at all. And there's simply, besides the fact that from a matter of common sense, there's no reason to do that. In this particular case, given the role of CFP and the statute, by the way, the statute specifically says in RSA 162.10.3 that the subcommittee is to consider all evidence. And let me give you one other.
Is there, before you do that, is there a reapplication option
I'm
for your
sorry?
client? A reapplication option?
The client always has an option to file a new application. Just like in Antrim Wind. I mean, in the Antrim Wind case, the first project, the SEC denied it, and a new application was filed.
And that would be tested against the
It-
old application to determine if there were material differences, or in this case, probably not?
Well, as you know, the law on that is if there is a material change, there's no res judicata. And therefore, if that's what Northern Pass decided to do, it would be at their risk, I suppose, if they wanted to file a new application and not.
But you'd need to know the basis for the denial. You'd need to be able to ferret out the basis for the denial in order to make that distinction.
One of the major problems in this case is simply this. What constitutes orderly develop or undue interference with orderly development of the region, when in this particular case, they never define what region they're talking about at all? That's a pretty vague term.
What role does precedent play in our analysis? Precedent of site evaluation committees, different projects.
Different committees do different things. However, from an administrative gloss point of view and from precedent in this case, on a particular issue, that is the issue of land use, the regulation says this. So let me try to answer your question more directly before I get to that.
Yeah.
It plays an important role because if you're an applicant coming before the SEC and you've got a project where there is already an existing transmission line, you know from past decisions of the SEC, the projects may be slightly different, et cetera, but the principles that should apply should be the same. That if you locate that new line in an existing right-of-way, past committees have found that that does not unduly interfere with the orderly development of the region. And there's logical reason for that. I think, in fact, you could make a good argument that the rule on land use was primarily developed to deal with new projects, because you're asking the question of, is it consistent with prevailing land uses in the affected communities? So that's the test. They're correct, the opponents are correct, that the rule, the SEC rule, says they don't have to follow their own precedent. But if you have a system that makes any sense, if there's precedent that you can look to, otherwise an applicant is completely in the dark as to what they need to show on land use in that issue, then at least you need to explain why you're not applying that precedent. And in this case, all they could say was, this project is different.
Well, but isn't part of the problem, I mean, I know you don't make a sort of unconstitutional delegation here, but isn't part of the problem here really that with a project of this size, I mean, you're right, the orderly development is, I think a strong argument can be made, it's sort of in the eye of the beholder, what is or is not. I mean, doesn't that sort of say that what the legislature really did here, whether it was a good idea or not, is they effectively delegated a political decision to the site evaluation committee? I mean, presumably the legislature could have said, this project will be built and Eversource will get the eminent domain power to take whatever land they need to, on the one hand, or on the other hand, they could have said, this project will not be built. And instead, probably because, as with the Base Closure Commission or something, nobody wants to take political responsibility, they say, we'll have this other group decide it. And so they did.
Well, if I understand your question, Your Honor, it's essentially, is this an unconstitutional delegation? And we're not arguing that the site evaluation rule is unconstitutional on its face. But in this case, there's an important distinction, which is this subcommittee never undertook that analysis. If this subcommittee had said, we've got evidence down below, we know what the impact of this project, start with this. They're all estimates. These are future predictions about what this project, the impact this project is going to have. And in areas like real estate values and land and tourism, all of the experts in this case agreed you can't quantify it. Almost in tourism, it's impossible to quantify. So if they had said, look, we measure the effect down here on the economy, we evaluate that against the impacts on land use or whether it's prevailing land use, and we take all that up to the level of undue interference with the orderly development of the region, and our decision is that this would or would not unduly interfere with the orderly development of a region as we have defined it. This would be a very different case. If you look at the SRP case as an example, they considered aesthetics first. They evaluated aesthetics in connection with the orderly development of the region. When they got to the final analysis, what they said is, there are 4 towns that are affected by this. 2 of them vehemently oppose this project.
Does S stand for Seacoast?
Seacoast Reliability Project, right.
Isn't that case on appeal?
It is on appeal, Your Honor. However, what the subcommittee in that case said was, these 4 towns do not constitute the region. The region is the Seacoast area. And when we apply this test to that region, we do not believe there's undue interference.
But it seems to me you're faulting the commission. It's got a statute that the legislature put together, and you're faulting them for not precisely dealing with or defining what will not unduly interfere with orderly development, and also the other notions. And so, but they're doing the best they can, and isn't the problem with the legislature in terms of
Perhaps.
not providing a definition?
Well, perhaps, but the subcommittee could have done far better than what they did.
Well,
They
did
could have-
did the applicant define the region?
Pardon?
According to the order, your expert, Mr. Varney, didn't define a region either with respect to land use. So how can we fault the subcommittee?
On the contrary, Your Honor, he did. He defined the region as the towns, as you would be required to do. The standard under land use is, is it consistent with the prevailing land uses in the affected communities? The affected communities, as defined in that portion of the rules, well, it's defined in any portion of the rules, is all the towns along the right-of-way and those that abut it. And Mr. Varney's report covered both of those issues.
But the legislature could have limited the entire analysis here to towns in which the project is to be built and abutting towns, but it introduces the notion of the region.
Well, and so does the subcommittee. So let me take the land use issue as an example. 3 problems with it. Well, I've covered one of them already, which is the importation of aesthetics into land use. The subcommittee in their rehearing order said very clearly, importing aesthetics into land use is not improper. It's improper if you don't analyze it the correct way, and they didn't do that. First of all, they conceded in the first of these 3 problems. They conceded that land use itself has no definition. It isn't a defined term. So what they essentially did was make up a definition and say, we're going to look at whether this project affects only the right-of-way. Was it overburden the right-of-way? Is there a tipping point? Is it too intense, et cetera? Well, that's not the standard. And in fact, all of
Isn't
the
it a
town...
relevant factor, however?
I'm sorry?
Isn't overburdening the current right-of-way a relevant factor for consideration?
No, because what does it mean?
It
There's
means
nothing in the rule-
something other than your normal wooden telephone pole.
We know this, we know it isn't in this case, Your Honor, for 2 reasons. Number one, the subcommittee itself took it back. They said in their rehearing order, we didn't say that Mr. Varney didn't meet his burden of proof because he didn't consider it, because we found that the project overburdened the right-of-way. He just didn't consider it. Well, how would any applicant know in advance that you should consider it, particularly when, in this case, the Public Utilities Commission has already said, with respect to this project, that overburdening the right-of-way is an issue for the superior courts and not for the administrative agencies.
Defined by the easement language or the language of the governing documents.
Exactly, Your Honor. So, and in that point, when they get around to trying to describe what land use is, they describe it as land use surrounding the right-of-way, surrounding properties, surrounding areas, in the area of the quarter, the neighborhood. So when we're asking, what does the prevailing land use relate to? How do we know? Because they don't deal with the affected communities. 2 points. One is the total land area of the right-of-way of this entire project is less than 1% of the land area of every town along the right-of-way except two, Franklin and Whitefield.
So
And
are
it-
you saying it's improper for the committee to have taken into account the visual impact of new structures from wherever they can be seen within a community or within a region? Was that wrong?
Yes, in this case. And the reason it was wrong was because there is a very specific way to determine, as I've said, what the visual impact of this project would be. Step back for 1 second. Visual impact. What experts do is they go out and they lay out the terrain of this project, they lay out the towers, and then the computer tells them where, just from a visual viewpoint, where is the project visible? You can look at the map, so it has hotspots on the map to show it. And by that, it means
In essence, defining a different region for the purpose of visual impact.
well, you have to make the visual impact assessment first,
Right.
and then you have to figure out
Right,
whether,
yeah.
if it has an impact, what region does it have an impact on? So you do that, and if any portion of the line, the top 2 inches of any portion of a transmission tower of the line is visible, it counts. Then the visual impact assessment says, okay, overlay on that all of the scenic resources within a particular area that might be affected by this. And then ask the question, using a visual impact analysis, on any one of those things, is there an unreasonable visual impact? Can it be mitigated by shrubbery or trees or whatever? And then overall make the determination. And as I said, if you're talking about rural character and you're concerned about the effect of the project on the town green or the village, that's all covered by scenic resources. It's
What
all
if the impact of the visual impact is a decrease in property value? Did Mr.
Property value-
Powell,
property value is a-
Mr. Powell testified, apparently, and didn't he say that these towers would have an impact because of their visual impact on valuation?
He did in a purely anecdotal way, in the sense that without the visual impact study, you don't know that. You can have an opinion on it, but property values are a little bit different, Your Honor, and they're different in this respect. In property values, people assume, either rightly or wrongly, that a transmission line will have an effect on real estate values. However, when Dr. Chalmers did his report, he looked at 25 studies and 58 individual property sales to address the question of whether there was, in this case, an actual impact on property values. And those objective studies determine whether that visual impact applies. And what Dr. Chalmers said is his conclusion from those studies was, if you have a home that is within 100 feet of the right-of-way, and if you did not have view of the line previously, and now have a partial view or a complete view, you may be affected by that, and that's the reason for the property value.
So do I understand correctly, his testimony was he only considered homes within 100 feet of the right-of-way for possible impact on property value, is that right?
Yes and no, Your Honor. What he did, his conclusion was that, in his view, homes within 100 feet of the right-of-way would be primarily the ones that were affected. But he also indicated that others might be. You don't know that until you actually, for example, in the property value guarantee, whether you're eligible for it is actually determined as when the project begins. You go out and actually look at the house and determine it. As an example, there's only one house within 100 feet of the right-of-way in the upper 40 miles of this project. So others may, the evidence in the record was that, as you might expect, that the impact on property value decreases with distance from the line. And everyone agreed in this case. So when you're 500 feet from the line, there really is no effect at all. So I hope that answers your question.
Well, but you responded in terms of Mr. Chalmers and the review of reports and studies that he did, but the fact is that the committee found him not to be credible or reliable. Isn't that true?
That is correct. And the committee had evidence in the record from KRA that the effect, they had evidence in the record from the Department of Energy's environmental impact statement and from KRA that the impact on property values across this line would be $10 to $30 million. That was an estimate of the impact that the subcommittee could have taken into effect. And it clearly could have said, we approve this project subject to a property value guarantee that extends out to pick a number. They never considered the mitigating measure, notwithstanding that in their decision, they said clearly, well, in their deliberations, or during the hearing rather, they said this is always something we can come back to.
But you know, I'm sorry, go
The
ahead.
subcommittee appeared to fault the applicant for not really addressing the impacts of construction on the project with respect to the orderly development of the region. What evidence was there that your client put before the committee on that issue?
Well, two things, Your Honor. On the construction piece, notwithstanding a long introduction to the problems with construction, like there wasn't a traffic management plan, et cetera, ultimately, the subcommittee at page 115 of their order said, we don't think that's a reason to deny this project. What they actually said was, it's the one place in their order where they sort of make it clear this project unduly interferes with the orderly development of the region, is on these local roads up north. 4.5 miles of roads affected by a 192-mile line. And because there may be some confusion in the record on this, let me just say what this line is. 192 miles, 100 miles in existing right-of-way, 60 miles underground, 24 miles in the Wagner Forest privately owned land. The subcommittee specifically found that that did not affect, that was consistent with prevailing land uses. So you've got 8 miles, privately owned by an affiliate of Northern Pass. That's in which there are, in those towns, no master plan or zoning ordinances. So what they said was, it's a real catch-22. What they said was, we don't believe that we can do the work that would result in proper construction of the project on these local roads. And you didn't give us enough evidence to say that if this were delegated to a contractor, that would solve the problem. Well, in fact, there was plenty of evidence in the record when Mr. Icapino, the subcommittee's counsel, specifically asked the transportation, or the transportation expert panel in this case, whether different options could be applied, including could we approve and hire a contractor to oversee this project in these local roads, answerable to the SEC. The evidence was, certainly, it's done all the time. And the Department of Transportation's representative on this panel specifically said that he did not believe that this project, any more than any other project in New Hampshire, would interfere with construction or would interfere with orderly development.
Mr. Glan, can I go back to something you said at the beginning of your answer? I think you said that there was, that they didn't consider mitigation with regard to a certain aspect of this. And I guess you've raised, I know you made that point in your brief in a number of places, but your opponents say that at least with respect to a number of those were things that your client as the applicant opposed. And so I guess my question is this: your view that the SEC should have considered in deciding whether to grant the application things, mitigation things, including particularly things that your client opposed. I mean, isn't underlying that theory that the SEC had that obligation, it seems to me is sort of a sense that the SEC is supposed to view these projects with a view towards granting the application, that there's sort of some presumption that if there's a way to get to this, you should allow it. And that seems to me to be, in some ways at least, inconsistent with the burden of proof. I mean, why can't they say, look, you're the applicant, you made this, you proposed this, we don't think you've met your burden of proof, and case closed, so to speak.
Well, in this particular case, what they did and said was, we are not going to consider those mitigating conditions at all, because we don't think you gave us enough evidence. The fact of the matter is we did, and what they did was unreasonably separate the burden of proof from mitigation. The burden of proof in these cases is always central to the issue of mitigation. And we know why they did that. Because in their deliberations, when they set up the vote to stop, what Commissioner Bailey said was, I'm worried that if we continue our deliberations, we will really need to figure out what conditions we could impose on a lot of things. And that's not going to be simple, and it's not going to be fast. And there's a lot more things to appeal. With respect, that's not the role of an administrative agency to decide whether there are more things to appeal.
Well, throughout your brief, you have quotes from members of the committee. And why should we give any heed to the comments of the committee? There's a 200 and some page final order, and that speaks for the committee rather than whatever particular committee members might have said.
Well, both sides complain about the same thing. They say you shouldn't consider it all, but their briefs are replete with it. The reason you should consider it.
Well, maybe we just
if you
won't
make the decision,
pay attention to any of it.
So I can make that easy. If you make the decision that none of those deliberative comments are germane, those deliberative comments found their way into the order. And we make that point in our brief. So it isn't just the deliberation, they're part of the brief. And if I could make one other point. There's a critical problem in this case with the way they dealt with what they themselves described as an issue in this case that could be outcome determinative. And that's the forward capacity market issue.
I'm
Say
sorry.
that again, please.
The forward capacity market issue. Capacity market is simply energy companies get paid to supply energy and to reserve capacity. They said, they make a finding, we find that there will be no savings from the capacity market, based on supposedly the record and their improper interpretation of what they say was an admission that we made. But here's the problem with that. The evidence in the record was, from our expert, that these benefits would return close to $500 million in benefits. From their expert, 3 scenarios. Each one of those would return, say, the first one, $300 million, the second, $250 million, the third one, 0. And their expert said, we can't give you a determination of the probability that any one of those 3 scenarios will occur. If it's outcome determinative, their job was to determine the outcome, and they never did so. What they never said, well, we think it's more likely that this scenario will apply than that scenario. And ultimately, while we recognize that the final decision is not one that is based solely on numbers, on dollar numbers, because the committee might decide, well, there's $1.5 billion of benefits over here, but we think the impact over here is going to be different from that. We really can't quantify it, if they'd made the decision. But on this particular issue, one that they said might have changed the outcome of this case, they simply punted. So I have nothing else, if you have no further questions.
Oh, well, since you have a minute, I do have a question.
I suspected that. Your Honor.
The statute talks about due consideration being given to the views of municipal and regional planning commissions and municipal governing bodies, and you take issue with the fact that the committee looked at master plans, saying that, they're not enforceable as zoning, which is true, but how else are communities supposed to speak? And don't they speak through their master plan? And wasn't it proper for the committee to take that into account?
Well, that's another problem with the statute, Your Honor, which is that this subcommittee imposed a burden on us to satisfy the municipals. We didn't adequately address their concerns. There's no burden in the rules or the statute on that at all. We are required to provide those municipal views as part of our application, and they're entitled to consider them. And in this particular case, what they actually said was that we failed to provide credible evidence to reconcile the alleged inconsistency of the project with the goals and purposes of the master plan and zoning ordinances. Now, I don't know how we ever satisfy the goals and purposes, but here's the issue on those towns. There were 31 towns along this line. This order, the 287-page order, provides evidence from 12 of those towns as to what they thought of this project. Of those 12 towns, 4, the line was underground. So from an aesthetic point of view, There was no real reason to believe there'd be any impact at all. On the other 8, all of the individuals who testified, and by the way, there was no expert who opposed Mr. Varney, who offered evidence on land use. All those people basically talked about rural character and scenic beauty. And that ultimately was the way they made their decision. So if you're going, again, I go back, and I'm probably repeating myself, but it's worth it here, which is, there's a proxy for that. You know how to determine it. And they simply never did it. They never even addressed it.
Do I correctly recall that 22 towns intervened in this matter to oppose the project?
I'm sorry that they're...
Did 22 towns intervene to
Right, but
oppose
they
the
didn't-
project?
They didn't cite evidence from those towns. They cited it from the 12. And another point, if I can finish, my light is on, is, as the subcommittee found, many of these towns simply stiff-armed the project. Plymouth is a great example. The town was supposed to be underground, the line was moved to be underground in Plymouth to address other issues. And that underground proposal was it would go through the town green in Plymouth. Eversource offered to move the line. Plymouth said, no, we're not even going to talk to you about that. And we have evidence in the record of the selectmen's meeting in which they did that. And other towns did exactly the same thing. Easton, for example. Not only are we not going to talk to you and offer to enter into a memorandum of understanding, which 4 towns did, but we're going to solicit the help of other towns to oppose this project. Now, if that's what the towns are going to do, I don't know how we could have done more to satisfy them. Thank you.
Thank you, Mr. Klein. The court will take a brief recess. Counsel?
Thank you, Your Honor. May it please the Court, Chris Aslan from the Department of Justice, and I'm appearing as counsel for the public. At its core, this case came down to a simple set of facts. The subcommittee found 3 of the applicant's 5 witnesses on orderly development unreliable and not credible. And without credible evidence on 3 of the 8 factors under orderly development, the subcommittee found that the applicants had not met their burden to prove facts sufficient for the subcommittee to make the required finding that the project would not unduly interfere with the orderly development of the region. As the Court's well aware, on appeal, the credibility determinations and factual findings by the subcommittee, which was the trier of fact, are entitled to substantial deference and are not to be second-guessed by the courts or overturned unless there's essentially no rational way that a fact finder could reach the same outcome based on the record evidence.
Was the subcommittee required to consider the information provided by counsel for the public?
Yes, Your Honor, and the committee did consider the evidence. One of the main arguments that the applicants have made in this case is essentially that they somehow know what the committee considered or didn't consider. And I think, as Justice Lynn pointed out earlier, there's a presumption that an administrative body sitting as an adjudicatory unit has heard all the evidence, which I believe is undisputed. There were thousands of pages of record evidence
But
here.
they only deliberated on, let's say, a quarter of the considerations.
That's correct, Your Honor. And so that argument that they didn't consider the evidence really boils down to an argument that the subcommittee didn't deliberate on all parts of the evidence. But that argument has been waived by the appellants here. On page 16 of their reply brief, they acknowledge that they did not brief the legal argument that they must deliberate on all parts of the application in order to meet the standard.
Well, that's a question of whether they must find all the parts, not whether they should deliberate on all the evidence.
Well, I believe
It seems like you're saying 2 different things here. They were to assume that they considered all the evidence even though they only deliberated on some of it.
Well, I guess I'm trying to say 2 things, and I'll try and straighten it out for you if I can. I believe that Mr. Glahn acknowledged they are not arguing that there was a requirement for the subcommittee to deliberate on all factors under the statutory scheme.
To decide all factors, right?
Or to deliberate on them at all. So I believe that argument's waived. What we can say is that the committee did have all of that information in their heads. They looked at the case and they looked at the credibility of the witnesses. And there, I think, to get to your point more specifically, if you look at the statutory language that the applicant is relying on, there are two provisions. There's one in RSA 162H:10, paragraph 3, which says essentially that the subcommittee must consider and weigh the evidence, all evidence that's presented to them. That's really no more than the standard role of any tribunal to hear any trier of fact, is to hear the evidence and give it its weight. It doesn't create some sort of special procedural due process right other than the right to be heard. And that is not at issue here. There's no question that
Did
the
the
applicant was heard.
subcommittee draw any conclusions from the visual impact studies?
From the visual impact studies themselves?
Yeah.
Probably not. And I think that's an important distinction to make that the appellants have raised. There's a difference under both the statutory scheme and the regulations between visual impacts with regard to orderly development and visual impacts with regard to the aesthetics analysis. Aesthetics, as has been stated, is very tightly regulated. It's a specific scheme. It requires a visual impact statement or assessment. But it also only looks at scenic resources. The definition of scenic resource is limited. It's much smaller than all parts of a community, which is what orderly development is looking at. It's
Was the
impact.
credibility of any of the visual impact study authors determined by the subcommittee?
It was not. The committee did not reach that piece of the analysis.
Was visual impact part of any of the analyses of the real estate experts?
It was. I think it's important to consider, with regard to orderly development, visual impacts is interwoven throughout. As you heard Attorney Glahn talk about what the definition of an affected community is, orderly development with regard to land use specifically looks at the impact to affected communities under the regulations. And that is all the towns through which the project passes and adjacent towns. The only possible relevance for concluding that big of an area is because of visual impacts from the project. You wouldn't have, if the right-of-way goes through one town 10 miles away, obviously the right-of-way isn't impacting them directly. It would only be through visual impact. So it's interwoven into the orderly development analysis at the outset.
But the visual impact of this project, as Mr. Glahn has told us, is minimal in terms of the percentage of the size of the project itself.
Well, he was referring, I believe, to the size of the right-of-way as a relationship to the size of the towns. But the visual impact itself stretches for miles. In some places, as you're aware from the state, this passes through the White Mountains or adjacent to the White Mountains. This is a hilly area. There are parts of this project that can be seen for more than 10 miles. Of course, it's small at that distance, but it still has a visual impact. And so to suggest that aesthetics, or that visual impacts can only be viewed through the lens of the aesthetics analysis, I think mixes up what the statute requires. Orderly development is its own separate finding that's required. Aesthetics is, again, a separate,
So
and
how
they have
does the
different standards.
subcommittee evaluate this perhaps 10-mile visual impact, if not based on the expert studies? Do they use their own knowledge or presumptions?
Well, there was quite a bit of evidence presented by dozens of witnesses about the visual impact of the structures and the wires in this project, as well as the substations and transition stations. It wasn't limited to the visual experts, which again, were focused on the specific scenic resource impacts under the regulatory regime for aesthetics.
Can I ask you, Mr. Gaslin, is it your position that in deciding whether or not an applicant has met its burden of proof, that the mitigation factors that are offered either by the applicant or by opponents are required to be considered by the SEC in deciding, let's say, whether there will be an adverse impact on orderly development?
Yes, Your Honor, I think there's some misconception in the briefing about what we mean by mitigation. And in part, every project has mitigation built into it. There are requirements under the regulations for the applicant to explain how it's mitigating impacts. They don't come in and say, we're going to build the biggest, most impactful project possible. They say, well, we want this project and we've done these things to reduce impacts. That's at the front end. Then there's a separate category of things which are proposed conditions. Some of those proposed conditions will further mitigate the impacts. In this case, the applicant had presented its case. It presented its the project, including its mitigation factors, and then it also said it would be willing to do some things in terms of conditions, but it opposed a host of other proposed conditions by other parties, including counsel for the public. And the burden of proof in terms of mitigation, I don't think mitigation flows directly through the burden of proof. The burden of proof is simply they have to prove facts sufficient.
Well, but you know,
for the
I mean,
finding.
I understand, but isn't the problem with that is that if you put mitigation sort of outside the burden of proof, then wouldn't it logically follow that if an applicant satisfies the burden of proof, then the SEC can say, well, you've met your burden of proof. That's it. Mitigation doesn't matter. You've met, you know, what you need to do, and so these mitigation things may be nice, but the applicant doesn't have to do that.
I disagree slightly, Your Honor. Conditions is a discretionary power of the committee. So even if the applicant were to meet its burden of proof without any mitigating factors, the committee still has the discretion to add additional conditions to the project to further mitigate, maybe below the standard of proof. And that's in RSA 162H:16, paragraph 6. It says that the committee may impose whatever conditions it deems necessary to meet the purposes of the statute. And so it kind of goes back to one of the big issues of this statute, which is that it places a very high burden on the applicant because it requires the committee to make negative findings. It's not just a sort of standard preponderance of the evidence test. It is a negative finding on 4 criteria that must be made: that the project will not unduly interfere with the orderly development, will not have an unreasonable adverse effect on aesthetics, etc. That's difficult. So in that statutory scheme, if there's any doubt about whether there could be an undue interference or an unreasonable adverse effect, that means that the burden has not been met.
Well, I mean, I wonder that if, you know, I'm wondering if that doesn't go too far the other way. In other words, Mr. Glahn, it would seem to me, some of his arguments would suggest that the statute envisions kind of a presumption that these will be approved, which seems to be inconsistent with the burden of proof. On the other hand, if any negative impact, I mean, nothing would ever be built.
Well, it's not any negative impact, but if there's a possibility that it will be an undue interference or an unreasonable adverse effect, that means they haven't met their burden to prove facts sufficient to say there will not.
Possibility?
Well, their burden is to show that there will not be an unreasonable impact or an undue interference. So the burden is heavily weighted on the applicants, and that's reflected in the rules. It requires the applicants specifically to carry that burden of both production and of proof.
But they can meet their burden through evidence introduced by the counsel for the public.
They could
Can they?
potentially, but they would have to present that evidence in favor of their case. In this case, the applicants did exactly the opposite. They refuted the counsel for the public's experts throughout the proceedings, and in their final brief said they should be essentially ignored because they're wrong, and then waited until
But isn't that part of the way this is set up? I mean, counsel for the public plays a very unique role. The applicant pays for counsel for the public, so it's kind of in the middle, and the applicant is within its rights to disagree, but then it's up to the committee to weigh. Just because the applicant disagrees with what counsel for the public says doesn't mean they are not able to rely on it.
Well, I think the committee certainly can and did rely on counsel for public's experts. The experts that counsel for public presented, one of their primary roles was to test the evidence and the analysis by the applicants, and they found, Carrie in particular, found that the applicants' experts on property values and tourism were not credible, and that is ultimately what the subcommittee
But
found.
provided an alternative.
They provided an alternative in the sense that they did a less than full analysis of the impacts. It's important to remember that while counsel for public has a special role here, it is not the applicant. It does not control all the information about the project. It can't propose or change the project. It can only point out flaws and say, well, based on the information we have and in the time frame that we have, which is truncated compared to an applicant, we can present a rough estimate of where we think the impacts may be. And that's what the experts did here. They said, well, we don't have a full analysis, but we can give you kind of a ballpark figure. And if you look through the record, you'll see that the Council for the Public's experts' opinions are replete with caveats, that these are just potential outcomes based on certain assumptions, and they're not trying to project the actual impacts. I think that the council, or the committee rather, heard that and didn't try to rely on that to fill the applicant's burden of proof, which again, it's the applicant's burden, not Council for the Public or any other intervener's burden to
What
prove.
role does precedent play in terms of other site evaluation committee decisions?
Well,
And how
under-
these various factors are evaluated?
Under the statute, there's certainly a recognition that the committee can look to past committee actions.
To define
And
things
consider.
such as region or land use?
Potentially, although those are purposefully vague terms, I think, but in the statute. There's no
Was the
definition.
region ever defined here?
I don't believe that the committee, in this case, came to a final decision on what the region is. And in fact, region has different meanings for different parts of the analysis. But what's important is they didn't get there because there was a lack of sufficient evidence for them to reach that stage of the analysis. They got to the point of saying, well, we don't have evidence from the applicant on property values impacts. We don't have evidence from the applicant that's credible on tourism. And we don't have evidence from the applicant on land use that's credible and that we can build, either weigh the factors together, or really that we got to the point where we had to define, well, does that mean in this region it's too much of an impact or not? They fell short at the burden of production. They did not have credible evidence. Just like any case where you have a burden to produce
Despite
evidence.
that these experts had provided credible evidence in other circumstances, and these reports were surprisingly similar to those.
Yes, Your Honor, and I think you're referring to the Merrimack Valley project, which preceded this one, where some of the same experts presented substantially similar reports.
Right.
The difference in that case was there was a non-controversial case. There was no municipal entities that challenged or even showed up to the case. There was one intervener. And frankly, that evidence wasn't particularly challenged.
So does the burden of proof for production change if it's a controversial case?
No, the burden stays the same, but if no one comes forward to challenge the evidence in a detailed way, then the subcommittee is left with the evidence that they have. And if they themselves haven't found an outside expert or by their own expertise have found flaws, then they may approve it.
What importance should we attach to the word unduly in conjunction with unduly interfere? It's not just the project interferes with the orderly development, it's unduly. And how did the committee deal with that?
Well, again, Your Honor, these are some of the vague terms in the statute that I think are intentionally vague. As this court recognized last year in the Mary Allen appeal case, the legislature delegated significant authority to the SEC to make these kinds of decisions and to make findings. Undue suggests more than just interfere. It's like a reasonable person standard. It is vague, but there's a way for the committee to look at the evidence and decide whether it's too much interference. And I would agree that it's not a statute of high clarity on that.
So how are we supposed to define due consideration being given to the views of municipalities?
Well, similarly, due consideration means, I think, is a little more clear. It means that they have to give some consideration to it, but they're not bound by it. In this case, with regard to the municipal views, I think there's a misconception by the applicant that they were required in some way to satisfy the municipalities. I think what the committee was really saying is, we find the municipal views to be persuasive. In fact, that's what they say in the brief. Or
But
in the order.
how can an applicant give due consideration to a town or city that's giving them the stiff arm?
Well, they can't, and the due consideration is that the committee has to give to the views due consideration. The applicant doesn't have to give any consideration to the towns if they don't want to, but it's at their peril. If the towns come forward with credible evidence that there's going to be an impact to them in their land use or other property values were the two things primarily here, if the applicant hasn't shown that those alleged impacts are incorrect, then they risk not meeting their burden.
Before you wind up, would you respond to Attorney Glonn's assessment that this project really only impacts 40 or 50 miles of a dirt road, somewhere in Coos County?
Well, I think what Attorney Glahn was trying to say is that the only finding in the order that there was an actual undue interference with orderly development related to the municipally controlled roads in the North Country, which are a small segment of the project. But it goes back to the bigger picture here. This case was decided not on a finding of undue interference, but on a finding that they failed to meet their burden of proof because they basically had holes. There's, depending on how you count, 6, 7, or 8 categories or factors that the committee is required by its rules to consider when it reaches the orderly development of the region finding. And 3 of those had no credible evidence from the applicants. And if you have 7 buckets to fill, and 3 of them are empty, it's pretty hard to weigh the factors, and it's pretty hard to show that you've met your burden of proof, which is clearly put on the applicant in this case.
Do you know of any other site evaluation committee decisions that stopped at the first leg of the stool, so to speak, orderly development of the region, and didn't go on to address the other 3 or total of 4 interconnected issues?
There's at least one other case where the committee denied a project, and that's the Antrim Wind project. And in that case, the committee said it would go through and deliberate on all the factors, which it did, but it didn't actually reach a decision on all the factors. It didn't make a decision on the financial and managerial capacity, which became an issue on remand under the Fisher v. Dover scenario, and whether that was res judicata. But there's such a paucity of cases that have been denied by the SEC that that's really the only one that comes to mind. But I do think it's important to recognize that this case really came back to that finding of not meeting their burden, and it's not a question of whether they deliberated, which I believe has been waived, but whether they could have gone farther on this record.
So were a new application to come in, what would be the parameters of analyzing Fisher v. Dover
Well, I think it's
under this decision?
Yeah. Well, I don't think this decision has any bearing on the Fisher v. Dover analysis. The Fisher v. Dover analysis would be based on the project and the attributes of the project.
So the same application could come in, just with different supporting documentation?
I don't think so. I think you would have to have a slightly different project in order to meet the Fisher v. Dover test.
Well, it would also depend on time, right? I mean, if they came in with the exact same application, but it was 10 years later or something, that might be a different situation.
And indeed, things have changed even in the year and a half since this decision. The world of energy has changed, and the factors on the ground have certainly changed, which would make it challenging on a remand.
So just to follow up on that, if the world is changing and if we were to agree with Mr. Glahn that there were errors here, if we sent it back, should it be a redo or should it be on the record? And what do we do about the fact that there are different members?
Well, I think it's difficult to see a path towards a redo because that would require this court to find that the credibility determinations on the 3 witnesses were improper in some way, and the record is replete with support for those decisions. If you don't undo that credibility finding, then you really aren't undoing the orderly development determination here, and under the statutory scheme, there's no way a certificate can issue. So a redo wouldn't really do much. You could remand it for further deliberations, which may be just a sort of exercise in perfection. But to change the outcome of the case as a denial, you would have to undo that orderly development decision or finding. I think it is a challenge also with regard to the changing body of the SEC members. While they can read the transcripts, there was significant 70 days of testimony here. They wouldn't be able to have the in-person view of those witnesses to make the credibility findings that this committee did in the first instance. So it would change the dynamic significantly. My light's been on for a little while, so I will step down.
Thank you, Mr. Rath.
Thank you.
Good morning. May it please the court, Amy Manzali here for the Forest Society. I have about 3 minutes of opening remarks, and then I welcome your questions. My key point this morning, and I want to focus on this, appellants did not meet their burden of proof. and therefore this court should affirm. Now, there are two parts to how appellants did not meet their burden of proof. First, appellants did not present sufficient evidence. The law clearly required, appellants to present certain evidence, but they did not. Second, appellants did not present credible evidence. After experiencing appellants' witnesses firsthand, the subcommittee correctly found, as a matter of fact, that some of the evidence they presented was not credible. Let me turn to insufficiency first. I'm going to discuss construction, which is just one of many examples of law that the appellants were required to present, but which they did not. Appellants' witnesses failed to consider the impact the construction period may have on land use, on tourism, and on property values.
Mr. Glahn told us earlier that his expert, Mr. Varney, did address that very point.
Mr. Varney did not address the impact the construction period would have on land use. He did talk about the roads up north, but that was the operation of the project. None of the witnesses addressed the 2-year construction period, which would be a big deal. 20 to 25 concurrent
Does that
sites.
get done at this stage or later in collaboration with DOT and the municipalities affected? Or do you have to address each and every mile of the 192-mile corridor with a plan in advance?
It gets addressed now. Site 30109 talks about construction and operation. That is the phrase from that law. And it says that the appellant is to provide an estimate of the effects of construction and operation on all of these various pieces of orderly development that we've talked about: land use, property values, tourism.
An estimate or a traffic plan?
The regulatory language is an estimate of the effects. The practice at the SEC is that a traffic plan would be included in that bundle of the estimate of effects.
At this point in time?
Historically, it would have been included at this point in time. Going to your point, it was not included at this point in time, I think because of the large scope of this project. And to Attorney Glahn's point, the subcommittee did ultimately find, okay, we can do without a traffic management plan for most of this project right now. Now I want to turn to credibility. And again, this is just one example of many instances of evidence that was not credible. The subcommittee was correct when it described Mr. Nichols' flawed online survey as dubious and misleading. For example, Mr. Nichols drew from the survey unsupportable conclusions about tourists to New Hampshire, such as 9% believe the presence of power lines is a benefit, and that is why they come to New Hampshire. And 6% believe potential traffic delays are a benefit, and that is why they come to New Hampshire. Now, how did Mr. Nichols get there? His poorly worded question in the online survey forced respondents to rank power lines as an attribute. In the face, this is exactly the kind of unreliable evidence that the subcommittee correctly found, as a matter of law, was not credible. So in the face of appellants not having presented what the law required, such as the analysis of construction period impacts, and presenting evidence that was not credible, such as land use, tourism, and real estate, the subcommittee correctly decided appellant did not meet its burden of proof and denied the application.
As a matter of law, can the committee fill those gaps with evidence introduced by the counsel for the public?
Yes, they could. But in this case, on the whole, evidence from counsel for the public did not favor the project. The evidence from Cavett and Rockler and the other witnesses found tremendous impacts. They did not in any way have an ultimate opinion that this project would not unduly interfere with orderly development. Also, as Attorney Aslan mentioned, they didn't undertake the analysis that would be required to be undertaken. So I won't repeat his comments, but essentially, evidence from counsel for the public was too general to sustain the appellant's burden of proof. Now, let me talk a little bit about the development process. Developers do not receive approval merely upon submission of an application. If that were the case, in the context of the SEC, that would render much of 162H completely meaningless.
But that's not what happened here. You had 2 years of evidence and hearings.
True, but appellant's position seems to be that there's some sort of entitlement, that when you submit the application and you go through the process, you should therefore get an approval. That's not the way development works. Developers have to present the required evidence, and it has to be credible. The decision maker needs to have sufficient credible evidence to measure the evidence up against the standards of whatever approval process they're going through, be it a variance process or a citing process under 162H. Appellant's evidence was not sufficient and was not credible, so they were not entitled to approval. Appellant said it best in its opening brief, quote, "The rules require applicants to provide these estimates so that a subcommittee can weigh all estimates of effects and determine whether, taken together, they amount to undue interference with orderly development of the region." But here, the subcommittee couldn't do that because they didn't have the required evidence, and some of the evidence that did come in was correctly found, as a matter of fact, to be not credible. Now, let me turn to one of the reasons why appellant's evidence was insufficient. Their witnesses used invented methodologies, some of them never before used, for example, like Mr. Nichols, and these methods excluded, reduced, and narrowed the field of consideration at every step of the way. And appellants ignore these shortcomings. And again, this left the subcommittee lacking sufficient evidence to determine whether the project would unduly interfere with orderly development. Now let me talk about why what Dr. Chalmers presented does not provide what the law requires. Dr. Chalmers actually said that his report, quote, "wasn't Northern Pass specific. Quote, "It didn't address the issue of the impact of the project on local and regional real estate markets." That's how he described his own evidence. Now, Site 30109B, as we've talked about, it requires an assessment of the effect of the proposed facility on real estate values in the affected communities. There are 3 big components there that the subcommittee correctly found Dr. Chalmers did not even address, leaving aside credibility issues. Substantively, the proposed project, he didn't address that. His materials talk and think about other high-voltage transmission line projects, projects which are not similar to the Northern Pass project. Real estate, he missed most of that. He talked about residential, single-family, detached homes. That's it. When that was pointed out, he then did a belated sole study on McKenna's condominium here in Concord. That's it. He didn't do commercial, he didn't do multifamily residential beyond McKenna's, conservation, retail, duplexes, industrial, he missed all of that. And then he missed a large part of the host community, of the affected communities. Affected communities includes, as we've heard, the host communities. The communities the project would go through. Next, those communities that abut it. And it actually includes a third category, any other municipality expected to be affected. And again, that is to account for view impacts. It is clear that view impacts are part of the undue interference standard. So the subcommittee correctly found evidence insufficient with respect to property values to determine how far from the project the impact on property values will reach. And that's why when they tried to consider the proposed condition of the property value guarantee, they found they couldn't, because they lacked the information about how far these property value impacts might reach. Now, I want to clarify about Mr. Varney. Mr. Varney did not look at land uses outside of the right-of-way. Sure, there's a smattering of sentences in his report mentioning a couple things outside of the right-of-way, but that is not what the law requires. Site 30109A requires 2 things. a description of the prevailing land uses in the affected communities, and how the proposed facility is or is not consistent with such land uses.
Hasn't that traditionally been limited to the land that's directly affected by the project, i.e. farmland being converted to some energy facility?
I think that's true
Traditionally, yes.
traditionally. And I also think it's important to note that the rules we're dealing with here are relatively new, and these rules were not in place for the bulk of the SEC's precedent, where analysis was traditionally looking at the existing utility right-of-way corridor. So the law
Let me
has-
just ask you,
Sure.
Mr. Glahn makes the point that the overburdening issue, that belongs in Superior Court, not here. What's your response to that?
I disagree with that. It is clear that a project such as this project could be so big that it could have an impact to land uses outside of the right-of-way. That is why the law requires looking at the prevailing land uses outside of the right-of-way.
The issue of overburdening turns on the language of the easement and the reasonable use, whereas what you're saying is you have to look beyond that parcel.
Yes, the orderly development of the region looks at the region. And with respect to land use, the region is defined as the affected communities, which is, as I mentioned, host, abutting, and then anyone else who could be expected to be affected,
According to the new rule.
according to the new rules, which appellants helped write. So, because Mr. Varney did not present the required evidence on land uses outside of the right-of-way, and whether they would or would not be consistent with the existing land uses, the subcommittee correctly found it lacked sufficient evidence to determine, quote, the extent to which the siting, construction, and operation of the proposed facility will affect land use. Now, to a question that arose earlier, had appellants provided this analysis, this is how they might have satisfied the goals set forward in municipal documents. If they had analyzed these land uses in consideration with what municipal documents said, I don't know because they didn't provide this analysis, but they might have satisfied some of the concerns and some of the goals expressed in those documents.
What municipal documents are you talking about?
Master plans, zoning ordinances. Part of the conversation earlier today, there was a question about, well, how could an applicant satisfy a municipal master plan's goals? And so this process required in the law of analyzing land uses throughout the affected communities could help get at that.
And communities that might be affected.
Yes.
And is that how the committee defined region?
I think that's how the committee defined region in its rulemaking process. Region is a necessarily flexible term. It has a different meaning depending on the project. Are we talking about a 300-foot single cell tower, or are we talking about a series of 150 feet towers going 192 miles?
In this instance, there were various regions.
So in this instance, the applicant defined region for tourism as the state of New Hampshire, and for land use as the existing utility right-of-way, and for real estate values as 100 feet on either side of the towers.
How do we determine the difference between adverse impacts and undue adverse impacts in order to support the subcommittee's decision?
The legislature has put this duty on the Site Evaluation Committee. And the Site Evaluation Committee, it's worth noting, is comprised of subject matter experts. We have folks from environment, transportation.
So they're entitled to rely on their own knowledge and not the evidence that's put before them?
No, they apply their specialized knowledge to the evidence that is put before them. And that's why.
And is that application of their specialized knowledge reflected in the deliberations minutes or the order, or does that happen
I
off
can't.
the record, so
I
to
can't
speak.
say for sure, but I know that the practice is that, the representative from Department of Transportation is often the one talking about construction concerns, and the representative from Historic Resources is often the one talking about historic resources, but I can't say for sure what this record reflects.
And what weight should we give to statements by individual members during the deliberation?
None. I see my time is up, Your Honor. In closing, this case presents no substantial question of law. The record contains competent evidence to support the subcommittee's findings of fact. The subcommittee correctly decided appellants did not present sufficient credible evidence. Accordingly, the Society for the Protection of New Hampshire Forests respectfully requests this court affirm the subcommittee's decision. Thank you.
Thank you.
A little shorter. May it please the court, my name's Danielle Pasek. I represent the city of Concord, and I am also here today on behalf of the other towns who filed a brief asking this court to affirm the SEC's decision. Of the 32 municipalities that this project was proposed to run through, 30 expressed concerns about the project's impacts, and 22 took the additional step of filing for intervention in the SEC proceeding. The opposition by municipalities of this project was unprecedented, but that does not mean that the SEC simply deferred to the municipal views. And their decision makes key factual findings that make that clear. There were approximately 40 municipal witnesses who testified at the SEC's proceedings, and those witnesses included members of planning boards, professional planning staff, members of conservation commissions, members of select boards, and city council. And after the SEC reviewed the testimony of those witnesses, it made the factual finding that the testimony on orderly development that they presented was thoughtful, consistent, and relevant to the issues. And that is in direct contrast to the SEC's opinion about the experts presented by the applicants on the issues of tourism, property values, and land use, which the SEC found were not credible and that they could not rely on the reports and the opinions of those experts. The SEC also made the key factual finding that it agreed with the concerns raised by the municipalities about impacts on land use. And it made the key factual finding that this project would have a large and a negative impact on land use in many of the affected communities. And those findings, as Attorney Aslan has already referenced, are critical on this appeal because, as this court has recognized, the role on appeal is not to second guess those findings or to reweigh the evidence. The SEC heard 70 days of hearings. They reviewed tens of thousands of pages of pre-filed testimony, of exhibits, of public comments, and there should be no question that under RSA 541.13, there's competent evidence in the record to support the SEC's findings. And we ask that this court affirm the decision. There are a few points that I do want to make in addition to that. And first, I want to talk about this argument raised in the applicant's brief that municipalities simply do not support large energy projects. That is incorrect and is not supported by a review of past projects in this state. There have been many projects that municipalities have supported. This project was not one of them because this project was poorly designed and it was poorly executed. In the overhead section of this project, where there is an existing corridor, the right-of-way was simply too narrow to accommodate a transmission line the magnitude that Northern Pass was proposing. The width of the right-of-way in many areas is only 250 feet.
Was there expert evidence that that width was too narrow?
there was the construction panel. One of the project's proposals was to take one of the existing lines and to relocate it and rebuild it on towers that were often more than double the size of the existing line. And
In a narrow right-of-way?
in the narrow right-of-way, and the reason that they needed to do that, and the reason that they needed to also install the new line in some areas on towers with common heights of 130 feet, was because the width of the right-of-way would not allow a different configuration. And when the experts were asked, why don't you just get more right-of-way along the side of this right-of-way? Why don't you acquire more land so that you're not having these unreasonable impacts and you're not having to have tall towers? The response was, we've made a decision that we don't want to expand the right-of-way. And that was a self-imposed decision that the applicants made.
So was it too narrow because of its off-site impacts, or was it too narrow for construction?
It was too narrow to put in a new line of the size that Northern Pass was proposing without having these adverse impacts where all of the poles all of a sudden needed to be created much higher than they currently are. In Concord, there was a...
I mean, I understand your point, but isn't it a little bit, I mean, what would have been the likely impact if Eversource had decided to take more land? I mean, isn't that sort of unfair to them to be suggesting, well, that you want to keep it in the same right of way? You should have taken more land. Isn't it likely that there would have been even more opposition if that had been the proposal?
Not necessarily. One of the major issues with this particular project was that the size and the scale of these new towers just did not fit into the communities. And one option to address
So
that...
regardless of the width of the right-of-way?
One option to address that is if you have at least lower towers, then the visual impacts throughout the community will be decreased. And they chose not to do that. It was their project. They get to choose how they want to site it and how they want to route it. But that doesn't mean that if you have a poorly designed project that doesn't make sense for communities, that the SEC needs to approve it. And the SEC agreed with the concerns raised by the municipalities that this industrial line that was being put into the existing corridor and the way it was being sited, they were concerned that there would be undue interference.
Well,
And
couldn't
when
the committee impose conditions requiring the applicant to acquire more land?
they could have conditions and they can require it. For example, if the applicant had suggested that as a mitigation proposal and the site evaluation committee agreed, then yes, they could have imposed that if they found that would have addressed the issue. And that they have done that in other cases. For example, in Portland Natural Gas, there was an area in that community where the underground gas pipeline was being sited in a portion of the town where the town had concerns about impacts of the rural character of that area. And ultimately, there were proposals to reroute the line in different areas that had been presented to the site evaluation committee in that proceeding, and the site evaluation committee required the applicant to reroute it in those other areas. But that was something at least that had been presented in the first instance by the applicant as a potential alternative. There were no alternatives in this situation that were presented by the applicant to deal with at least the area in the existing corridor and the size of the heights that we were looking at.
How does the issue of overburdening of the easement interact with what the committee had to do?
The overburdening analysis, the way I look at what the committee, why they analyzed it, it was really just a tool to explain that just because you have an existing corridor doesn't mean that there's never going to be additional impacts. And it was really to counter the land use experts' argument from the applicant who said, it's a right-of-way, it's a right-of-way, it doesn't matter how much infrastructure you put in it, there's never going to be an impact because it's a right-of-way. And the overburdening was really just a tool to counter that argument. I don't think they ever intended to make an argument or a finding that there would be an overburdening, at least for the individuals who had those easements on their land. In terms of the argument also that the SEC simply deferred to municipal views, which we disagree with, The Concord and many municipalities set forth testimony, and they presented exhibits, they had cross-examination of the applicant's experts, and the SEC ultimately found that they agreed with the concerns raised by those municipalities. And I think it's important to note that those municipal witnesses had extensive knowledge about their communities, and they had reviewed the construction plans, and they were able to identify with specificity specific areas where they had concerns about impacts. And that is in direct contrast to the land use expert presented by the applicants. He agreed, and he admitted, that he was not familiar with the specifics of the project in each of the communities, and he admitted that he did not do any sort of study or analysis of the construction plans in Concord or other towns. And the Site Evaluation Committee rejected his opinion. And they said that he was not credible, and among other concerns expressed by the committee about that land use expert, they found that he made no attempt to identify where the impacts of the project would be large or small. And there are many concerns that were raised by municipalities. And I know that there was a question as to, well, when does it become undue? And what is that consideration? In terms of concerns about areas where there would be undue impacts that were at least presented to the Site Evaluation Committee, one example would be in Bethlehem, where there was a proposal to install new transmission lines and a transition station right at the entrance to the town. And in that area, immediately adjacent to where the transition station was proposed to be sited, the town at the same time was looking at a proposal for a development of a new $20 million high-end hotel. And the town had serious concerns about having a transition station sited right next to a proposed hotel. And when the town tried to work with Eversource to get information about whether or not that transition station could get moved, they weren't able to get any adequate information. And at the end of the record, the Site Evaluation Committee was told by the applicants, just assume that the transition station is not getting moved. In Concord, there were areas where the poles were going to be 125 feet tall, right in the vicinity of residential areas like McKenna's Purchase and Alton Woods. And in the North Country, where Attorney Glahn had mentioned this small piece of a local road that had concerns, the North Country did have, first of all, a new overhead transmission line that was being proposed, which would have interrupted pristine views. And in the areas where the applicant proposed to bury the line, they made a proposal to use old historic roads, which the applicant, even in their own application, admitted were bucolic and winding and narrow. Those winding, narrow roads were never intended to hold a buried high-voltage transmission line. And the SEC had concerns about how this line would get buried in that area that were never adequately addressed by the applicant.
What is the state of the record regarding the additional property taxes that would be paid by the applicant?
The state of the record is that there's a certain minimum amount under a methodology used that the applicant had explained would be guaranteed. The municipalities had questions about whether that methodology was correct, but what there was evidence was, for many of the municipalities, was we're not going to approve or support a project just because of the dollars or tax dollars it might bring into a community. That's short-sighted. What they wanted to do was to have development that they could support in the long term, and so these tax dollars really weren't sufficient to buy the support of the municipalities. In the end, the applicant tries to blame the Site Evaluation Committee, and it also tries to blame the municipalities for not getting the approval of their project, but the fault is its own. And the applicant does argue that the Site Evaluation Committee should have looked at the economic benefits of the project, but economics alone are not sufficient for the Site Evaluation Committee to grant a certificate of site and
But
facility.
the site evaluation committee have looked at all the factors, though. Not economics alone, not orderly development alone, but all of the factors.
They look at all of them, and in this particular case, there's issues such as public welfare, and there's land use planning.
But the
that-
site evaluation committee didn't look at all the factors, did it?
For orderly development, they did.
But not the others.
They didn't look at aesthetics, but that's a separate category from land use planning. They also didn't look at, for example, the natural environment and impacts to wildlife and other natural habitat.
And aesthetics is different than visual impact. They're related, but they're different.
They're very different. Aesthetics deals with scenic resources. It's a very narrow category, as Attorney Aslan had talked about already. When the Site Evaluation Committee looks at public welfare and land use planning, they are looking at issues that they want to make sure that the rural character of communities are preserved. And when you look at the towns that are rural along this route, like Pittsburgh and Bethlehem and Deerfield, the Site Evaluation Committee had legitimate concerns about this proposal and the impacts on those towns. They ultimately unanimously ruled that the applicants failed to meet their burden of proof, and we ask you to affirm that unanimous decision. Thank you.
Thank you. Mr. Blunt?
Thank you, Your Honor. I'd like to go back. I'd like to start by going back to a question that Justice Donovan asked, and it has to do with this visual impact issue because, as Ms. Pasek said, aesthetics is different. It's different from consideration of orderly development. I correctly said that the right-of-way, for purposes of whether prevailing land uses are affected, is 1% of the land or less in every town along the right-of-way. Now, if you're looking at, is it consistent with the prevailing land uses in the community, you got to take into effect that it's only 1%. And if you took into effect the affected communities and the abutting communities, it would be far less. But you asked about visual impact. Had they analyzed the visual impact study? On average, across this line, the increased area of towns that are affected, the acreage of the town that has a view of this line on any theory, on the visual impact theory, is less than 1% on average across the line. In the city of Concord, for example, 79/100ths of 1% will have an increased view of some kind of this line. So when we're talking about orderly development of the region, that's a pretty small impact.
But Mr. Chalmers didn't analyze the impact on property values for properties outside of that 100-foot corridor on either side, is that right?
No, what Mr. Chalmers said, Dr. Chalmers said, is it's order of magnitude determination. And his conclusion was that it wouldn't have an effect beyond 100 feet. Now, again, affected communities is the test for that. But the subcommittee clearly could have said, well, we think it's going to be further. They said that. We think it's going to affect a larger area. They never made any factual findings on that at all. But if they thought that, they clearly could have said, your property value guarantee should cover that. So they have completely misrepresented what Mr. Varney did, and I want to clear that up. The court has Mr. Varney's record, or his report, and you can look at it. In the back of his supplement to his report is a list of every town along the right-of-way, showing every land use along the right-of-way. And he draws the conclusion that at every place along the right-of-way, this utility quarter, after all, most of it has grown up around this utility quarter, and it's appropriate for land use to put this in a place where there already is a quarter. But Mr. Varney analyzed every single town. He analyzed the heights of the towers. He analyzed where they would be moved. On
So
aesthetics,
is the failure to look at master plans, is that sort of a red herring?
well, he did look at every master plan, and he has a report that covers it. And one of his points was, there isn't a single master plan anywhere along of these towns that addresses how you deal with a utility right-of-way. They're simply not covered in the master plan, for good reason, because they are utility rights-of-way, and that's the right place to put them. So, an important concession by Ms. Manzelli you can consider the counsel for the public's evidence in making this determination. And let's look at what they actually said about their determinations. Because it isn't just a question of them saying, well, this is just some wild guess as to what we think the impact is going to be. What they said was, KRA on property values. Our approach allows the SEC to see how much loss is at risk and what that represents to the state economy using standard impact estimation techniques. What they said on tourism. Question in their supplemental, in their pre-filed testimony. What do you estimate the project's impact on tourism to be? Summarize your assessment of the potential impact on tourism. That's what their evidence was. I want to talk just for a second. I think in some respects, Ms. Manzelli has conceded the point, but this issue, I think you may have raised it, Justice Hans Marconi, about the fact that we disagreed with the CFP's experts below. We did, and the subcommittee didn't buy our criticism of them. They accepted their conclusions about what this project would do. Having accepted that, why not consider it? Because that's what gave them the estimate of the impact of the project, which then allowed them to roll all that up and make a determination. In effect, the burden of proof was their deus ex machina here for saying, we don't have to make that determination in the end, because we don't think there's enough down here. But there was enough down there. And one other point on that, which is, I think it was Ms. Manzelli who started with the issue of credibility versus reliability, which started with credibility. In the rehearing deliberations, the chair of the committee said, we didn't find that these people weren't credible in the sense that we didn't believe them. We just thought their testimony was unreliable.
And what's the importance of that distinction?
Well, it's important for this reason, Your Honor. When you go back, it is the reliability of the evidence based on the Seacoast Anti-Pollution decision of this court is that that another panel could easily look at that evidence and determine whether they think it's reliable, they can read the transcripts, and they can consider the CFP's experts. So one other point, or there may be one more than one, but at least one more. Ms. Pasek said that the subcommittee made a finding that this project had a large and negative impact on land use. That's simply untrue. In their rehearing order, they specifically said the subcommittee did not find that the project would have a negative impact on land use because it would overburden the private way. More to the point, there is nowhere in this record where they made any finding that this project would have a particular effect on land use. Nowhere. On the roads up north, it's 4.5 miles. And I failed to make one point before it get picked up in the SRP decision.
But it may be a very picturesque 4.1
sorry?
mile. It may be a very picturesque set of miles.
It may well be, Your Honor.
Yes.
And one of the reasons to deal with that picturesque is put it underground. And yes, it may be complicated to do that. But what they did was put us in a position where we could not win. In other words, we don't know how to resolve this. What they actually said is, so you got two options. Either the administrator of the SEC can do this, or we can appoint a contractor to work with you to do it. And then they said, either of those options would unduly interfere with the orderly development of the region, with no factual finding as to why it would. But in the SRP decision, dealing with a similar kind of thing, where towns had entered into memoranda of understanding, and as I said, there were at least 4 towns here that did that, and I believe they were Campton, Thornton, Franklin, and I forget the 4th. Sound like Rick Perry. But in the SRP decision, they specifically said, the SEC administrator is authorized to retain consultants to assist her in conducting the duties assigned by the memorandum of understanding, and at her discretion to retain consultants that may assist her in satisfying the duties assigned to her by those memos of understanding. There's simply no reason why the same thing couldn't have been done here.
Can I just, and I realize, I concede right at the outset that this is certainly not any kind of a perfect analogy, but if we try to analogize what happened here, and it's sort of procedurally, to, let's say, just a civil case before a jury, in which, let's say, it's a motor vehicle accident, and the plaintiff, to recover, has to show negligence and causation and damages. And the jury gets the case, and they decide that the plaintiff wasn't negligent. And so they return a verdict for the defendant. To reverse that decision, wouldn't we have to be able to say that the jury had to find the defendant negligent? And so by analogy, don't we have to say that the evidence before the tribunal, before the SEC, was such that they had to find, not just that it was sort of up in the air, they could go one way or the other, but they had to find that there would be no impact on orderly development?
No. The analogy isn't perfect, and here's why. Because this is a quasi-judicial body that has a duty to investigate, and a duty under the statute. They have an investigatory function as well as a judicial function, and they have an obligation under the statute to consider all evidence. And one final point.
So does that relieve the applicant of any burden?
No, of course not. Because if the applicant's burden is to provide facts sufficient for them to make the overall determination. And in this case, where the CFP comes in, decides to be part of this case, comes in and offers evidence that allows them to make that determination, that's a different issue. And finally, on conditions, just to get to this point, their rule specifically requires them to consider conditions. 301.17 says, in determining whether a certificate should be issued, meaning whether or not, they shall consider, and one of the things they shall consider is conditions necessary to meet the objectives of the statute. The statute presumes there will be impact. And so when you're dealing with a statute that says undue interference or unreasonable adverse effects, you have to consider mitigation. I don't know if I answered your question, Justice Bassett, so thank you. My time is up. I appreciate it.
Thank you, Mr. Klein. Case submitted. Court stands in recess.